State of Texas versus Katherine Welch. Ma'am, are you Katherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report. And has everyone had an opportunity to review that report?
We have, Judge.
I have, Your Honor.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum this week.
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Smallfino has already stated, as well as I received the sentencing memorandum at 5:47 p.m. yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Smallfino, you've had time to review it as well?
Same, Your Honor.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to counsel. Did you both receive those as well?
Yes, Judge.
I did.
Okay. Is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right. Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think, our focus here is going to be on the topics that we talked about or write about in the sentencing memo. And, just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That
Okay.
is an option that doesn't cost the court anything. Or
Right.
the state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No, Your Honor.
All right, then argument.
Judge, I want to, I recognize this is a unique case and a unique ask that we're making here. This is not something small that we're asking for. I have sort of personally taken Katherine on over the last 3+ years, I guess almost 4 years, as a project for me, if that makes any sense. And what I mean by that is I really wanted to put to the test, could this person do everything that I asked her to do to at least get her an opportunity to be here in front of you asking what we're asking for? She exceeded my expectations by doing the 90-day inpatient rehabilitation. And while she was there, she started to explore with her counselors and her therapists there some of the underlying issues that went beyond just physical addiction, but actually had to do with her mental health and some of the things that she's experienced in her life. I'm not going to detail them on the record, but the court is aware of what those things are. Incredibly traumatic events that I think she had repressed and had never really addressed and explored. And so those counselors recommended not just aftercare, but a specific outpatient program to address some of the trauma issues that she's had. She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. She, sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report, if she felt she needed treatment, she said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. And I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means. And so, because a lot of times, as you know, Judge, private rehabilitation programs will just reject you if you've been clean for 3+ years, as she has. And so they just won't even accept you at all. So I think that was just a misunderstanding or a miscommunication between the probation officer and Katherine. But nonetheless, she's willing to do whatever the court chooses here. Additionally, we've been in contact with her current parole officer. They are willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from them. And then finally, Judge, you see, we didn't want to focus too much on support from the community because, again, this isn't just a run-of-the-mill case. This is a different focus. But she is married. She has a family. She recognizes the impact that all of this has had on her family and her relationships, the strain it has put on her husband, both financially and also emotionally. And she accepts responsibility for that and is asking the court to consider this extremely rare position that we're asking the court to take here. Obviously, if the court would like her to address the court, she is happy to do that, or I'm not sure how you want to proceed on that.
Okay, thank you. Ms. Malfino?
Judge, I don't envy the position that the court is in this morning. I do take very seriously the comments of Mr. Gertz. I take him at his word for that, and I hope that all of those things are true. It's difficult for me as a representative of Jefferson County and the state and the citizens that are on the roads every day to stand up and say I agree with probation, but I don't disagree with the things that Mr. Gertz has said and the information that is in his sentencing memo. To play the other side of the coin, does it suggest that she received the benefit of the doubt already by me waiving the habitual status that she could have been facing based on her number of priors? Does it seem in good conscience that I can say I ignore all of those priors? Absolutely not. But obviously, we have seen that her multiple trips to the penitentiary have resulted in no change of behavior until hopefully now in these last 3 years. And I do sympathize with Ms. Welch as an individual. Again, it's hard for me as a district attorney, assistant district attorney, to say that I concur with the punishment being probation, but I don't, again, disagree with the comments that Mr. Gertz has. We've had multiple conversations about this case. I know he's worked very diligently at it. I don't really know, Judge, and that's why it's before you, that putting her in prison for 20 years and her getting out in 2 versus an extensive probation period where she can continue the recovery she's been doing is a better option. But again, I don't know what is in the best interest of public safety. Unfortunately, none of us do. So I would defer to the court's wisdom and whatever you think is appropriate based on the volume of information.
All right, thank you. Anything else?
Would you like to say something, Judge?
Your Honor, I just want to say that the past was fueled by drugs and alcohol. I take complete responsibility for that. I did not know from very young when things happened in my life that it could have been, some of it could have been treated and stopped earlier if I had gotten help for my mental health. That after I received this DWI, that helped me get myself to a place that I could go into a treatment program and deal with some of those past traumas. In the past, I didn't. I medicated and drank to just forget about the pain, just numb myself out. I didn't know how else to deal with that until when I got on my mental health meds, and I have bipolar, I have PTSD, and my mind back then was very chaotic. And I just want to say, after I had my mental health meds, I was able to go through treatment at Santa Maria in Houston, and that place really saved my life. I did extensive 90-day treatment with trauma counselors. It was a trauma-informed community there. And also, when I completed that, I worked an outpatient program, but I still lived on their facility. I went to the sex trafficking and recovery program, and I was in that for about 8 months, where I got the state paid for the counseling for trauma still. And I just worked really hard in that. I got a job while I was in there. And then once that program was over, I moved to a sober living facility in Oxford House in Spring, and I worked there. And so I felt like I was strong enough to come home and do what I needed to do. And I was in the complete program for right out of a year. And I'm sorry, I'm very nervous today. And I know that my past record is, like Ryan said, atrocious. But you know, the things that I had to deal with within myself from when I was a little girl, those are things that you don't go to prison, even in their programs there, that you don't talk about. It's just, you just don't. And I'm asking you, please do not send me back to prison. I want to move forward. I have moved forward in my life, and this year that I've been in jail has given me more time to think and know that I am definitely headed in the right direction. I have a sponsor. I attend AA at home. I had moved on with my life as far as I could with my sobriety. I mean, I knew this charge was out there. And I think I made some really good choices with my Mid-County AA friends. They've helped me a lot. And I am open to anything. I will abide by all the rules and do anything that's asked of me. And I think, I know now that I'm responsible and capable of taking care of my business and my life.
Thank you. So, Ms. Welch, this Ms. Malfino probably said it yet best, and I get this often, and they don't envy my position, and this is the worst part of my job. But I worked hard to get here, and it's my job. Part of my job, it's several things, and it's to look at, obviously defendants and giving chances and things like that, but it also is about making our community safe. And I have to look back. This is your 10th DWI. It's not your 5th. It's not your 8th. It's the 10th. And while I understand the trauma that you went through, that you've been to safety 3 times. You've been given opportunities on probation where they were revoked. You've had opportunities while you were on parole to do what you have done now. And while I appreciate what you've done, and I think that's great, and my goal isn't to, to stop any improvement, but I can't, in my opinion, in good faith, go home tonight, look myself in the mirror and say I gave somebody on their 10th DWI that your last sentence was for 15 years in prison. The one before that was for 10. The one before that, you've gone to another 10 year, back in 09. I mean, this goes back to the 90s. You got a 10-year sentence in 2011. While you're on parole for that one, you get another one. So they give you 15 years and you get out and you're on parole and you do it again. The fact is, we're just lucky that you haven't killed someone in our community 9 times over, being given opportunities. I just can't do it. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find and your plea of true to the prior offense. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to sentence you to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not, well, I guess there was an agreement because the waiver of the enhancement, which could have been a 25 to life, as Mr. Gertz said. So I'm going to hand you the certification that shows this was an agreement. You've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read the written admonishment I provide you. If you have any questions about that, you can talk to Mr. Gertz. And Ms. Welch, I take no pleasure in this. This is extremely difficult for me. I understand to some extent addiction, and I understand that you are on a better path. However, there have been plenty of opportunities in the past where you were on a better path and you got back out and you got back on our roads again. And so good luck to you, ma'am. Thank you, Mr. Gertz and Ms. Malfino. Court will be adjourned.
Other 19-year-olds who don't do this, they get to go to bed when they want, wake up when they want, eat what they want, work out when they want. You don't get to do those things anymore because you committed a felony offense. And if you continue to act like you've been acting and not follow the rules, however insignificant you think those rules are, you're going to end up right back in here and you're going to end up going to prison for up to 10 years. Do you understand? Yes. So your life, you have to make some mature decisions as a young person who's probably not ready to make those decisions. It's going to be a conscious effort and a decision on your part to either do it or not do it, right? What's going to happen if I follow this is you're going to go to ISF. ISF is a 90-day program that's intended to help you make better decisions. But let me tell you what can happen. Between now and the time that you go to ISF, you're going to be in jail. If I get an incident report, it's a violation of your probation. You could get revoked off your probation before you ever go to ISF. Do you understand? And it's happened. Ask them out there. I'm tired of you young people acting like you're acting in our jail. They're tired of it. These people are just going to do their jobs, trying to go home go with their families, make a living, pay their bills, something that you hopefully will want to do at some point in your life. Instead, they got to go to jail and deal with this, the crap from you kids. But now you're an adult for these purposes. If you get to ISF and you don't make it through that program, or I get incident reports from ISF, they send me those, you're not going to get out. You're never going to see the light of day again. You're going to go to prison. It's that serious. Do you understand? Okay. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. Again, if you do everything you're supposed to, this is a great opportunity today. I don't want it to all be negative, because you have some very positive things. You don't have a felony conviction on your record. If you're a convicted felon, it changes your life in so many negative ways. You're not going to get certain jobs. If you want to go to trade schools or school or anything like that, or college, you're not going to be able to do certain things, live certain places, all of that. So you still have that opportunity. And if you get everything together and you follow the rules, at the end of your probation period, the case is dismissed. You will never have a felony conviction. This is the chance of your lifetime to change it and live like the rest of us live, okay? The other side, though, is if you violate any condition of probation, you'll be brought back into court. You'll be found guilty, so you would be a convicted felon. And then the punishment can be anywhere in that range from 2 years up to 10 years in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Again, I know there's other people out there, there's other young people that are acting up. It's going to be up to you to say, I'm not doing it. I don't want to go to prison. All right? All right, you can go back with the bailiff. Yes, ma'am. Hold on a second.
Before he goes, Judge, in light of the fact that you are giving him an opportunity after deferred on the felony in reviewing of his incident reports from the PSI themselves and his juvenile history, which is quite extensive.
Yes.
It is my intention to proceed, obviously with a plea bargain offer on those misdemeanors, but I think it would be important, at least with several of them, to have those on his record so that if he is back, we kind of know what we're going to do.
So you won't be able to go to ISF until you take care of those misdemeanors. They'll bring you over on a jail day to get those taken care of. Ms. Molfino will talk to that prosecutor. If you enter pleas on those, great. If you decide to go to trial, then you'll just have to wait to go to ISF until those take care of with the trial, okay? Also, I do want to make sure a condition of your probation is that you are not allowed to be in the possession of a firearm of any type. That means in a vehicle with anybody with a firearm. That means at a house where there are firearms. You are not allowed to be anywhere where there's firearms. If you're living somewhere where there's firearms, you either cannot live there or they have to have those out of the house or locked where you cannot have access to them. Do you understand?
Yes.
Okay, you go back with the bailiff. All right, you're Taylon Douglas.
Yes, ma'am.
And Mr. Douglas was previously in court, entered a plea of guilty to the third-degree felony offense of obstruction or retaliation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah, ma'am.
Any additions or corrections?
No, Your Honor.
Only that court is inclined to follow judge and certainly concur with the answer.
In addition, I have received, and you guys should have been given copies of jail incident reports. Have you all reviewed those as well?
We have them.
I'm not, but I take your word for it.
Okay. You don't like to follow rules, do you?
I follow the rules.
You do? You've been following the rules since you've been in jail? Kinda. Okay. So, how have you not followed the rules?
I don't know, just whenever, I say like whenever I get disrespected or something like that.
Oh, so when they disrespect you,
I just,
why do you think you deserve their respect?
cause I don't do nothing to disrespect them.
You don't? You don't? Sitting on the countertops, not getting down. Looks like trying to smoke in the bathroom. working out when you're not supposed to be working out, lying about it, saying you're brushing your teeth, teasing and cutting up with and being disrespectful, talking about the officers, act like a little kid. Taking food when you're not supposed to. Calling them some lovely names. B word. Tell them they're white and ugly.
That's what they said I said?
Mm-hmm.
I don't know. I don't remember.
You don't remember saying that? So here's the thing, how old are you?
19.
19. So you're now on a felony, or about to be, if I follow the agreement, which I don't have to do. You're about to be on a felony probation where you have to follow rules whether you like them or not because you've committed a felony offense. So you don't get to make all the decisions for yourself anymore, right?
Yes, sir.
Now. Michael Dyer, Mr. Rojas. Good morning. Are you Michael Dyer?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Dyer, in cause number 25, DCCR 1340, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from September 9th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Dyer is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand that?
Yeah.
And do you want to reject that offer and have your case set for trial?
Well, would you tell me that I have to sign it today because I don't have, I was gonna get another lawyer.
So here's the thing. Today, I just need to know, there's a couple of things. We'll take them in order. First of all, I need to know if you want to enter a plea of guilty and take the 15 years, or if you want to plead not guilty and go to trial. Okay, so I'll do the rejection and we'll get your case set for trial, okay? Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial quicker. Is that okay with
Is
you?
it the same thing? I still gotta go to trial no matter what?
Yeah. I mean, either you plead guilty and take the deal or you go to trial.
I guess I go to trial.
And are you okay if I appoint a new attorney today?
I guess I can go with this one.
You want to keep Mr. Rojas? All right, so Mr. Rojas will begin preparation for trial and we'll get it set for trial. You may go back with the bailiff. Sarah Jordan,
I don't know what we did her, Judge. She said she's gonna either hire Mr. Kimler or Mr. Smith with one more resetting.
okay, we'll just do a reset on Sarah Jordan's 2 cases then. And Gerodrick Randall, it's the sentencing. I'll have to take a break.
We came for a sentencing before, you rejected that because it's some new cases. We have a new plea.
Oh, okay, got it. Okay, so
No, they're not new cases in this court, no, but he picked up some new cases.
okay. So we already went through. All right, are you Gerodrick Randall?
Yes, ma'am.
And so did I just reset it or did I?
Hi.
What?
So in August, Your Honor, he pled true, and I think at that time we were looking at ISF as our agreement. When it was reset for an updated report, then we discovered he had
Yeah.
two new misdemeanors that occurred in August. And so I
Right.
filed a first amended motion October 22nd.
Okay,
So
but we need to go through
We need to
that.
be pleased to that, and then we have an agreement that the court's okay with.
Okay. All right. Will you waive the formal reading of the motion?
He will, Your Honor.
Mr. Randall, in clause number 24, DCCR 0543, I have a first amended motion to revoke your unadjudicated probation. And we're going to start kind of all over. I know we've gone through some of this, but we're going to get pleas of true or not true again on all of
And
them.
Your Honor, with your permission, we've agreed to plead to 1, 2, 3, and then the amended counts of 10 and 11, which cover the several new offenses, all
Right.
misdemeanors, but
Thank you. So it shows you were placed on probation October 7th of 2024 for aggravated robbery, and that was a 5-year deferred probation. Is that correct? The state's elected to proceed on counts 1, 2, 3, 10, and 11. Count 1 alleges that you violated your probation by committing the new offense of unlawful carrying a weapon May 3rd of 2025. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of evading arrest or detention May 3rd of 2025. And is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025. And is that true or not true?
True.
Count 10 alleges that you committed the offense of unlawful carrying a weapon July 13th of 2025. And is that true or not true?
True.
And then count 11 alleges that you committed the offense of evading arrest or detention July 13th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have paperwork now, again, on the case here that has your signature on it that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Randall's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of robbery, aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institution.
Judge, I feel like we may have originally pled him to the lesser.
I think we did lesser
robbery.
included.
Let me double check. And it may be because he's one of several co-defendants in that case, and I know at least one of them was pled to a lesser.
I have that we did plead him to a lesser included robbery back in August of 24.
That's correct, Judge. I'm looking at the PSI.
Let me double check with the paperwork, though. Hold on just a second. Can you pull up the original? Well, never mind. It'll probably be in here. Never mind. Hold on.
It was put down to judge robbery.
Okay. Does the state want to?
Yes, Your Honor, I'd ask that I be allowed to amend the motion to take out aggravated reflect the original.
Any objection to that?
No objection.
So I'm going to go back and just to make sure the record's clear, what you're on probation for is the lesser included offense of the second degree felony offense of robbery. So it's not aggravated, it's the second degree felony. And I'm going to make that modification amendment here on the motion with, let's see. I can figure out how to get all this done. Okay, so that being said, I'm going to find you guilty based on the pleas of true to counts 1, 2, 3, 10, and 11, find you guilty of the offense of robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
All right, court's just going to, I just need about a 5-10 minute break. We'll be in short recess.
All right, court's in recess.
And this is 25 DCCR 0108, 0109, and 0110. Mr. Bell's cases are set for trial to begin with jury selection on December the 1st. And what is the announcement?
Ready, Your Honor.
State's ready.
Has there been any change? It looks like that last plea bargain rejection was from May. And any change in negotiation or offers?
What was the offer back then? It's currently 20 on the table. I'm not sure what the offer was back then.
It's coming. Hold
It
on.
was 20, Judge, and
Okay.
I assume it will be Mr. Smith.
This shows 25 for habitual,
Okay.
and so was there something different?
I think we
that-
went down to 20.
There was a
Let me just-
20-year offer that
Yeah.
was previously rejected to proceed on non-habitual, but
Okay.
the trial
Yeah.
will proceed on habitual
Habitual, right.
and 4A.
So I want to make sure you understand, Mr. Bell, that the offer that the state has given is to go on, I guess probably count 1 and 2 instead of all of the counts that would make it a habitual offender for a 20-year term in prison. You have every right, again, not to take that and go to trial in a couple of weeks, but I do want to make sure you understand that after today, I will not accept that plea agreement. If you're found guilty and if those prior convictions are true, it means that your habitual status and the minimum punishment would be 25 years. Do you understand? All right, and you want to go forward with trial? All right, we'll get the cases numbered after docket and let you guys know as soon as docket's over. You can go back with the bailiff. Bless you. Yes, sir. Mr. Burbank, on Brandon Bell?
We'll just have a second.
Sure.
I might, 2 of those evidence.
Okay, on Williams as well?
Yes, Your
Ms. Perazo, on Traven Alexander?
all have to just.
Sure, yes, ma'am. Well, okay. Mr. Parker, are you ready on Jamarian Martin? It's a sentencing. Jamarian Martin. Okay.
I don't either.
The PSI's running huge now. PSI.
See, I haven't seen this whole packet. I just saw this, I guess. Not that it matters. It's all that's what they need.
And they're all underlined now. I don't know if you've noticed that.
What do you mean?
Like every sentence is underlined. They would like that yesterday. I don't know if yours is or not.
Mine's not been like that at
Oh,
all.
two dozen?
Well, they emailed me last week and then they got hard copies. And so it's.
That's weird looking. I don't know why. Okay, are you Jamarian Martin? And Mr. Martin was previously in court in cause number 25 DCCR 0196, entered a plea of guilty to burglary of a building. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Any additions or corrections?
Nowhere, Judge.
Only that the state would request $500 in restitution, Judge. I think my conversation with the PSI author in this case, Ms. Banks, was subsequent to her already sending it to the court. So we were able to determine it's $500 in restitution.
Okay.
And I would also ask if the court is inclined to follow it, that it be with a condition of ISF at the very least.
So that's, yes. So my biggest question is, with regard to ISF, it's either substance or cognitive. And so because there's some drug issues, but there's also, he's young. And so what I'm considering is ISF cognitive and then JCDI as when he gets out. Does that seem appropriate for what we've got here?
I think so, Judge.
I think so. He came to court and tested positive last time, but
Right.
probably would better address both with both of those programs. And then we could always follow up the state.
Yeah. Well, or, yeah.
Let's not go that route.
Okay, Mr. Martin, what I'm going to do, how old are you? 19. So my goal here today, and everyone's goal, is for you to be able to be successful. And so what's going to happen is you're going to be given some tools up front, not necessarily meant to be punishment, but meant to give you everything you need to change your life and be successful and go through this probation. So what that means, though, is if I do all of this now and then you violate later, coming back in and asking for another chance is probably not going to go very well. You understand? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. I am going to order $500 in restitution and that you follow all of the rules and conditions of probation. That's going to include entering and successfully completing the cognitive track of the ISF program, which is a 90-day program to help you make better decisions. And then when you get out, you're going to be ordered to enter and successfully complete the JCDI program, which is the Jefferson County Drug Intervention Program. That is an outpatient treatment program, but it's intensive and it's meant to help you get off all the drugs and things like that. So you're going to be able to be hopefully making better decisions, not using drug. And if you do all of that, this is an excellent opportunity because you're not a convicted felon. You don't have this felony conviction on your record. And if you successfully complete the probation, you will never have a felony conviction. The case will be dismissed at the end if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, convicted of the offense, which means you would be a convicted felon and sent to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement.
And that brings us to the end of this intense sentencing hearing. Katherine Welch came into court facing the consequences of a serious criminal history, but she also presented years of rehabilitation, treatment, sobriety, and a genuine effort to rebuild her life. The prosecution acknowledged the progress, the defense fought for another chance, and ultimately, the decision rested with the judge. This case raises a difficult question: how much should a person's past define their future? Was Katherine's rehabilitation enough to justify mercy, or did her history demand a harsher punishment? That's the balance the court had to consider. Now we want to hear from you. If you were the judge, would you give her another chance or send her back to prison? Drop your opinion in the comments, and if you found this courtroom breakdown interesting, make sure to like, subscribe, and turn on notifications for more real courtroom moments and legal analysis.